Okay, I'm confused. So are you,
I'm
y'all
sorry.
are splitting, oh, you doing it by yourself,
Yes,
okay. That's okay.
And then a 5 and a 3 and a 1.
Oh, I will have those.
You can use it.
So.
Judge, I'll take a 5 and a 1 if you wouldn't mind.
Yeah. Alright, so you can go get them lined up. Let me go grab my tea.
Yeah.
Have you just security kid? Security kid?
So,
All rise.
All right.
You can all be seated. Okay, ladies and gentlemen, so I can be heard. Welcome back from lunch. Having the state and the defense having rested and closed, we are now to the portion where I will read to you the court's charge. You have heard all the evidence and testimony that you will in this case. After reading the court's charge, the state of Texas will have the opportunity to do a closing argument. Then the defense will have the opportunity to do a closing argument. And as the law dictates, the state of Texas then has the opportunity to do the final closing arguments. After you've heard all the closing arguments from both sides, you will then receive the court's charge. After receiving the court's charge, you will then retire to the deliberation room. And at that point, we will be on your schedule. So, we have already put on the record, but I will ask once again, has both sides had the opportunity to review the court's charge?
Yes, sir.
Defense?
We have got.
And our state, are you ready to proceed with closing arguments?
Yes, sir.
Defense, are you ready?
That's right, Your Honor.
All right, thank you. This is cause number F1875401. The state of Texas versus Billy Chemirmir. Court's charge. Members of the jury, the defendant Billy Chemirmir stands charged by indictment with the offense of capital murder, alleged to have been committed on or about March 20th, 2018 in Dallas County, Texas. To this charge, the defendant has pleaded not guilty. The following instructions are the law applicable to this case. You are instructed that you may read these instructions as a whole. Offense definitions. A person commits murder if the person intentionally or knowingly causes the death of an individual. A person commits capital murder if the person commits murder as that term is herein defined, and the person intentionally commits the murder in the course of committing or attempting to commit burglary or robbery. A person commits burglary if, without the effective consent of the owner, the person enters a habitation and commits or attempts to commit a felony, theft, or an assault. A person commits robbery if, in the course of committing theft, as that term is herein defined, and with intent to obtain or maintain control of the property of another, the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits theft if the person unlawfully appropriates property with intent to deprive the owner of the property. Terms, definitions. Actor means a person whose criminal responsibility is an issue in a criminal action. Another means a person other than the actor. Appropriate means to acquire or otherwise exercise control over property other than real property. Appropriation of property is unlawful if it is without the owner's effective consent, or the property is stolen and the actor appropriates the property knowing it was stolen by another. Attempt to commit an offense occurs if, with specific intent to commit an offense, a person does an act amounting to more than mere preparation that tends but fails to affect the commission of the offense intended. Bodily injury means physical pain, illness, or any impairment of physical condition. Deadly weapon means anything that in the manner or its use or intended use is capable of causing death or serious bodily injury. Deprive means to withhold property from the owner permanently or for so extended a period of time that a major portion of the value or enjoyment of the property is lost to the owner. Effective consent means assent in fact, whether express or apparent, and includes consent by a person legally authorized to act for the owner. Consent is not effective if induced by force, threat, or fraud. Felony means an offense so designated by law or punishable by death or confinement in a penitentiary. Habitation means a structure or vehicle that is adapted for the overnight accommodation of persons and includes each separately secured or occupied portion of the structure or vehicle and each structure appurtenant to or connected with the structure or vehicle. In the course of committing theft means conduct that occurs in an attempt to commit during the commission or in immediate flight after the attempt or commission of theft. Individual means a human being who is alive. Owner means a person who has title to the property, possession of the property, whether lawful or not, or a greater right to possession of the property than the person charged. Person means an individual. Property means tangible or intangible personal property, including anything severed from land or a document including money that represents or embodies anything of value. Possession means actual care, custody, control, or management of property. Steal means to acquire property or service by theft. Mental state definitions. The following definitions apply to the offense of capital murder. A person acts intentionally or with intent with respect to a result of his conduct when it is his conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. The following definitions apply to the offense of burglary, robbery, and theft. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in the conduct or cause the result. A person acts knowingly or with knowledge with respect to the nature of his conduct or to consequences surrounding his conduct when he is aware of the nature of his conduct or that the circumstances exist. A person acts knowingly or with knowledge with respect to a result of his conduct when he is aware that his conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding his conduct or the result of his conduct when he is aware of but consciously disregards substantial and unjustifiable risk that circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all circumstances as viewed from the actor's standpoint. Capital murder. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant, Billy Chemirmir, did intentionally cause the death of Lou T. Harris, an individual hereinafter called deceased, by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of burglary of Lou T. Harris, then you will find the defendant guilty of capital murder as charged in the indictment. Or, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, that the defendant, Billy Chemirmir, did intentionally cause the death of Lou T. Harris, an individual hereinafter called deceased, by smothering the deceased with a pillow, a deadly weapon, or with hands, a deadly weapon, or with an unknown object, a deadly weapon, the exact nature and description of which is unknown and unknowable to the grand jury, and you further find beyond a reasonable doubt that the defendant was then and there in the course of committing or attempting to commit the offense of robbery of Lou T. Harris, then you will find the defendant guilty of capital murder as charged in the indictment. If you do not so believe, or if you have a reasonable doubt thereof, or if you are unable to agree, you will then consider whether the defendant is guilty of the lesser included offense of theft. Now, bearing in mind the foregoing instructions, if you unanimously find from the evidence beyond a reasonable doubt that on or about March 20th, 2018 in Dallas County, Texas, the defendant, Billy Chemirmir, did then and there unlawfully appropriate stolen property, to wit, a red jewelry box and jewelry of the value of $750 to $2,500, the said property having been stolen from Lou T. Harris, its lawful owner, and the defendant acquired said property knowing that it was stolen property, then you will find the defendant guilty of the lesser included offense of theft. If you do not so believe, or if you have a reasonable doubt thereof, you will follow the following instructions. If you should find from the evidence beyond a reasonable doubt that the defendant is guilty of the charged offense or of a lesser included offense, but you have reasonable doubt as to which offense he is guilty of, then you should resolve the doubt in the defendant's favor and find the defendant guilty of the lesser offense. It is not necessary for you to acquit the defendant of the greater charge in order to consider the lesser offense contained in the court's charge. If you believe the defendant is not guilty of any offense or have a reasonable doubt thereof, then you will acquit the defendant and say by your verdict not guilty. Presumptions and burden of proof. In all criminal cases, the burden of proof is on the state. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless you are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in this case. The state has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. This burden rests upon the state throughout the trial and never shifts to the defendant. If the state fails to meet its burden, you must acquit the defendant. It is not required that the state prove the defendant's guilt beyond all possible doubt. It is required that the state's proof excludes all reasonable doubt concerning the defendant's guilt. If in the event that you have a reasonable doubt as to the defendant's guilt after considering all the evidence before you and these instructions, you will acquit the defendant and say by your verdict not guilty. Evidentiary instructions. You are instructed that you are not to allow yourself to be influenced in any degree whatsoever by what you may think or surmise the opinion of the court to be. The court has no right by any word or any act to indicate any opinion respecting any matter of fact involved in this case, nor to indicate any desire respecting its outcome. The court has not intended to express any opinion upon any matter of fact in this case, and if you have observed anything which you have or may interpret as the court's opinion upon any matter of fact in this case, you must wholly disregard it. At times throughout the trial, the court has been called upon to pass on the question of whether or not certain offered evidence might be properly admitted. Do not be concerned with the reasons for such rulings and draw no inferences from them. Whether offered evidence is admissible is purely a question of law. In admitting evidence to which an objection is made, the court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. As to any offer of evidence that has been rejected by the court, you of course must not consider the same. As to any question to which an objection was sustained, you must not conjecture as to what the answer might have been or as to the reason for the objection. You are instructed that you may consider all the relevant facts and circumstances surrounding the alleged killing and the previous relationship existing between the defendant and the deceased, if any, together with all relevant facts and circumstances going to show the condition of the mind of the defendant at the time of the offense alleged in the indictment. You are instructed that if there is any testimony before you in this case regarding the defendant's having committed an offense other than the offense alleged against him in the indictment in this case, You cannot consider that testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense, if any was committed. And even then, you may only consider it in determining the motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident, if any, and for no other purpose. You are instructed that the defendant may testify in his own behalf if he chooses to do so. But if he elects not to do so, that fact cannot be taken by you as a circumstance against him or prejudice him in any way. The defendant has elected not to testify, and you are instructed that you cannot and must not refer to or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever. Concluding instructions. It is only from the witness stand that the jury is permitted to receive evidence regarding the case, and no juror is permitted to communicate to any other juror anything he may have heard regarding the case from any source other than the witness stand. In deliberating on this case, you are not to refer to or discuss any matter or issue not in evidence before you, and you are not to talk about this case to anyone not of your jury. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given to the testimony, but you are bound to receive and follow the law from the court. After you have retired to consider the verdict, no one has any authority to communicate with you except the bailiff who has you in charge. You may communicate with this court in writing, signed by your presiding juror, through the bailiff who has you in charge. Do not attempt to talk to the bailiff, the attorneys, or the court concerning any questions you may have. After argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of your presiding juror to preside at your deliberations, to reside at your deliberations, and to vote with you in arriving at a verdict. Your verdict must be unanimous. And after you have arrived at your verdict, you may use one of the attached forms by having your presiding judge sign the particular form that conforms to your verdict. How it works here. It is signed by me, Judge Raquel Rocky Jones, presiding judge of the 203rd Judicial District Court here in Dallas County, Texas. The last page you will see are the verdict forms. The verdict forms state, we, the jury, unanimously find the defendant guilty of capital murder as charged in the indictment. On the top line is a place for the foreman of the jury to sign their name and then to print their name under it. The next verdict form, we, the jury, unanimously find the defendant guilty of theft as included in the indictment. There is a space for the presiding juror, for the foreman of the jury, to sign their name, and then a line for them to print their name. The last verdict form is we, the jury, find the defendant not guilty. There is a line for the jury foreman to sign their name, and then a line for them to print their name. Having read the court's charge, state, are you ready to proceed with?
It is.
All right, we're closing argument. You may proceed, sir.
May it please court?
Yes.
Well, good afternoon. I would like to thank you on behalf of the District Attorney's Office. I'm going to take the opportunity because up here sometimes we forget to say everything we intend to. And on behalf of the defense attorneys, thank you for responding to your summonses. We want to thank you for coming down. We want to thank you for taking that oath last Thursday morning, early, before we even met you, that you will give what? True answers to all the questions propounded to you by the court or under its direction. We appreciate that. That allowed us to go through the process of talking about the law. And I spent about an hour doing that, going over the law that we anticipated would be a part of this case. But I didn't go over everything, and so I'm going to spend some time now with you going over what we did go over to remind you of that, and to go over with you now some things that are in the court's instructions that were not there. Okay, but one thing I want to remind you of, there are a couple of things going on here. Number one, I want to bring all this back that we're here as Americans participating in this American democracy with elected officials and public offices and the freedom to come down here and to do things that other countries won't allow. And they fight for it. And they fight each other and kill each other just for the right to have a piece of what we have. And all of this means that when we come here, we have to be bound by the law and the evidence and the instructions that the court gives you. But we're really here beyond that. Even though I'm going to spend some time talking about that, there's another bigger picture that we're here for. And I want to make certain that I start my remarks and that we don't lose track of that. Okay, and what we're really here talking about is a name in the indictment. And you have a picture of a very kind, gentle person. And you have some of her stuff. The things that were precious and meaningful to her have been offered into evidence. You know where they came from. I'm not going to go over that again. Okay, but those were the things that made up Lou T. Harris. And then, as we went through this case, we found out that Lou T. Harris, as you've seen from the exhibit, went from this kind and gentle and funny and well-traveled person to a dead body left in the place where she called home, and a place where we all go to seek refuge and rest and replenishment. And the issue here today is, how did she go from this to this? Was it a coughing fit? Was it a heart attack? Was it capital murder? And we have here in our presence some things that give us an idea, because they're in the indictment, the things we have to prove. And we have here something that all of us never really think about in this fashion. But it depends on who's in your presence and what they're willing to do. Something that you put your head on and go to rest and go to sleep and dream and replenish and refresh yourself ordinarily. We don't think about things the way other people do. But something like this is likely the instrument of death that put her in that picture and turned her from this person, this loving, kind person, to the way she was found. And so I want to go back and talk to you a little bit about what we talked about. We talked about circumstantial evidence. And I asked the question, does anybody out here feel that circumstantial evidence equals weak evidence? And some people raised their hands. And we talked about circumstantial and direct evidence. Direct evidence, most common form, is eyewitness. And we talked about the fact that eyewitness testimony has been used to convict people and put them in the penitentiary. And then we find out from circumstantial evidence they didn't do it. And this idea that circumstantial evidence equals weak evidence is stuff of movies and books and news and all that, but it's not real. Okay? And I asked the question, we put it up there, if we prove the case beyond a reasonable doubt via circumstantial evidence, could you return a verdict of guilty? If we proved it beyond a reasonable doubt. And if you had said no, you wouldn't be sitting here right now. You took that oath, and then we gave you another oath, the judge did. It said, are you going to true verdict render according to the law and the evidence in this case? And we counted on you at both times that you answered those correctly and that you meant your answers. And we're still counting on you right now that all of those oaths and all of those answers and the ability to follow the law, that you meant it. And if we proved it beyond a reasonable doubt, you return a verdict of guilty. And I want to point out to you, by the way, that when you read these instructions, which the judge will give to you, you have a chance to go back, even if she read them to you, okay? Okay, don't worry about that. You'll get that to read. You'll have it in your hand. But there's nothing in there about circumstantial or direct evidence. Okay, those are just tools. Those were things. We talked about that because we don't know, what you read, what you believe, what you think. And so we're obligated to go over these things to find out if there's going to be a problem. And out of all the 112 people here, we've now wound up with 14, and we know that we're happy and satisfied because you answered the questions, and we know you're going to follow the law. We don't have any question about that. Okay? But these instructions don't say circumstance. It just says we have to prove the elements of the offense beyond a reasonable doubt. And I'm going to go into that. Okay? What else? There was some talk about how you go about deliberate, you go off by yourself, you think it through by yourself. What? Really? That's nowhere in these instructions either. What the instruction says, you choose your foreperson. I think 4 minutes is, but let's use foreperson. Okay? and you deliberate. And you go through the charge, you go through the instructions, and you come to a conclusion. Okay? That's all. Anything else is a mere suggestion, not anything that you need to do. And I know some of you may have been on jury duty before, maybe served, so you know. Okay? So let's go back and look at these instructions and talk about some things. First of all, we have to prove that it's Miss Harris. I know somebody named Frances Harris. I keep saying that. Excuse me. Okay? Miss Harris, I'm going to call her. Okay? We have to prove that the person who caused her death did it intentionally. Okay? Why was it important to put those two MEs on? Not only talk about the petechiae, etc., and all that, but talk about smothering. And also talk about the mechanics of smothering somebody. Whether it's by either a pillow or hand or an unknown. Unknown means to the grand jury. Why is that important? Because we have to prove that this isn't an oops. This is an intentional killing. And what did you hear? You heard about what it would take to kill an 81-year-old woman, about 120 pounds or so, who had innocently gone to the Walmart, gone back home, and put her stuff about to put it up. And somebody came in, most likely, certainly a reasonable deduction and inference from the evidence because of this lipstick, okay? And everybody knows, let's use common sense, that's smeared on there, it ain't put on there. Nobody's wiping their mouth clean and getting ready for bed or anything off this pillow. Okay? But when you do that, you heard two different things, two different ideas. But the point from both doctors is it ain't quick and it ain't an accident and it takes time. 10 to 15 seconds, one said, to do what? Lose consciousness. Okay, well, you're not dead. And the person's still breathing. But it takes some more. Maybe a minute, maybe 2 minutes, or 3 minutes, one said. And what's going on through all that? A struggle, a fight. To do what? To live, to breathe, to do the things we do so we have the opportunity, if we want to come sit in a courtroom or do whatever we want to do, to interact with our son-in-law. And when things like that happen, when you have the willingness and the ability to put somebody to death over that extended period of time, that is intending to cause the death of the person. No ifs, ands, or buts about it. Certainly brought up by the evidence. Let's talk about some other things. We know that the law talks about capital murder. And it says, and we went over this the other day, that capital murder is the intentional killing of an individual, right? But it's during the course of what? A robbery or a burglary. We went over that. The judge read it. Once again, you'll have these instructions with you. It's going to look just like what we put up on the screen the other day, okay? You know what? Those are so simple and so intuitive. Now that you know the difference between burglary and robbery, I'm not going to spend a bunch of time talking about it because it's already in the instructions. But one thing for certain is burglary is not, remember I said it's not break and enter, it's just enter without the person's consent. And there's absolutely no reason here to think that people will go to Walmart and bring their stuff home and go into their house, give consent for some stranger to walk in and commit these acts. Okay? That's a burglary. A robbery. Okay, robbery doesn't mean banging them up, this, that, and the other. Okay, but it's what? Robbery. And you have those definitions. Once again, they're so simple, I won't go over them. They're so intuitive now that you know them. But one thing, we don't have to prove by 12 of you that it was a burglary, or 12 of you that it was a robbery, any combination, because it says capital murder is the intentional killing of a person during the course of either robbery or burglary. If 11 of you are one way and one's the other way, fine. If it's the other way, fine. Any combination doesn't matter, fine. It's all capital murder. Okay? What else did we know? When we get down to this idea of how death was caused, we went over this and we explained this to you. Put my glasses on so I can make sure I get it right. I want you to remember page 6. Okay? Just right. You don't need to write. It's page 6. What this is called an application paragraph, plural, 2. Okay? This is where the judge puts the law together and says either this or that. One says burglary, one says robbery.
But the most important thing is it says what? How? Death by smothering the deceased with a pillow, or, not and, or hands, or an unknown object, a deadly weapon, which we went over the other day, and that's in here. We're not going to spend a lot of time on that. Obviously, it's a deadly weapon because she wound up dead. Okay? What about that? How do we deal with that? If one of you thinks it's a pillow and 11 thinks it's something else, that's okay. As long as it's within the framework of those descriptions. Or any other way. And we went over that a week ago today, about this time of the day. And you all said you understood it. You all said you could apply it. And we trusted you then, and we're trusting you now. And in addition to that, you came in this courtroom on Monday and you raised your hands and you said, I will a true verdict render according to what? The law and the evidence, so help you God. Okay? So that's that. I want to go a few pages more in. There's some stuff in here about theft. I'm going to skip it. I want to go to page 10. Because on page 10 are some things that we didn't talk about. Okay? We had a limited amount of time and space, and we didn't talk about it. And sometimes we don't know everything that's going to come into a case until the judge has an opportunity to rule, etc. But you have now heard not only about Miss Harris, but you heard about these two lovely ladies also. And you heard about their demise, one's almost demise. Thank God for her family and her. She was able to what? Die a natural death. But you heard what happened to her. Why is that in there? Why did we bring that? Because the law allows us to. It says on page 10, you are instructed if there's any testimony before you in this case regarding defendants having committed an offense other than the offense alleged against him in the indictment, you cannot consider, listen to this carefully, that testimony for any purpose unless you find and believe beyond a reasonable doubt that the defendant committed such other offense. Okay? Well, yeah. Why do you think we got all those cell phones and all those locations and all those security cams and all that jewelry and whose phone it was on and offer-ups and all the places that it gets sold and all the dollar amounts that get put in somebody's pocket? I'm not going to go over that. He will. You've seen it. You just heard it. But you understand, okay, that a phone can solve a crime. Security cameras can solve a crime. And they tell the truth. Okay? When they got the picture of it, got it on your phone, that's the truth. You can't run a high from. Unless you find beyond a reasonable doubt defendant such other offense. If any was committed, it's fine. Even then, listen to this. Got to follow this. You may only consider it in determining the motive, the opportunity, the intent, the preparation, plan, knowledge, identity, absence of mistake, or lack of accident. No coughing fits here or heart attacks. If any, and for no other purpose. Follow that. Don't go outside that paragraph. Because when you took that oath to follow the law, that's what you got to follow. Let's talk about this. So, does this stuff come in every case? No, of course not. What if I'm charged with stealing a motorcycle out of Oak Cliff? Okay? And I go to trial. Okay? Can they bring in some other offenses? Well, maybe. Can they bring in the fact that I was violating the fishing laws of the state of Washington to prove that I stole a motorcycle? Of course not. Doesn't have anything to do with it. However, what does the law say? It talks about the word signature. And what it means is the actions of the different things, the different offenses are so close that they fit like a glove. That if you believe it, and you believe they committed it, those actions, before it becomes admissible, need to be so alike that the conclusion is, for those purposes and those purposes only, but you got the right person. Okay? What's the commonality of these cases where it fits like a glove? Where we don't have to be concerned if we got the wrong person. 3 elderly women in their homes, jumped, reasonable inference from the evidence. We also know from Mr. Plink that somebody likes to hang out over there at 5000 Old Shepherd with the same license plate and the same car. We also know that somebody likes to hang out at Walmart on television, on the camera, allegedly looking like, wanting people to think, doing what? Talking on the phone, but you heard what the phone record said. No conversation going on. We also know what? That somebody came up to Miss Harris as she was checking out and went right down that aisle and took a look. And walked out, went to the next aisle. She goes out and goes out, goes to the right into the restroom area. The lady's working there. Miss Harris goes by, goes out. We know that a silver car, like that car, as far as Miss Brooks, around that. Okay, we know all that. We know what? Everybody got something put over their faces. We know for one thing for certain. We know that she got a pillow put over her face. That thing of comfort that you put your head on and rest and go to sleep and hopefully have some good dreams. Thank God she had a pacemaker. That's the only reason this man was able to sit down and do a deposition of her and find out what happened. Could she tell you much about the identity? Let's not go into that. No. But where's her stuff? Her stuff is where everybody else's stuff is. The things that we treasure, that we spend our money on, that we get as gifts, that are mementos to us, that those are the things that we count on to be a part of ourselves, that we love, that respect, that our husbands and wives and relatives that we buy for ourselves, that create our identity. They all somehow kind of wind up right over there. And that's the commonality in these cases. Okay? We got smothering with her. We got, no question, smothering with her. She was able to tell you. Okay? And from what Dr. Bernard found out, and his young associate, once they knew everything, okay, this lady should have been taken to the ME's office. We admit that. Unfortunately, she wasn't. But we do have what? All the other facts. Where's her safe? Gone. Where's her stuff? Gone. Where's her ring? Gone. Who winds up over at Dallas Gold Exchange? Somebody in this courtroom. Who winds up on offer of taking pictures on hands of these people's stuff if they aren't caught too soon? And then it gets in the dumpster and otherwise in the hand. Somebody in this courtroom. Okay? And that's why these cases come in, because they fit like a glove to fill in the details, to let you know we didn't make a mistake. We respect the process. We respect the law. And we have put on a strong case, beyond a reasonable doubt, as to the guilt of Mr. Chemirmir. I want to go through a couple of other things. And once again, this bears repeating just briefly. After argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of your presiding juror to preside at your deliberations and vote with you in arriving at a verdict. The verdict must be unanimous. Guess what? We agree. Remember one of the things I told y'all the other day? Is that... Thank you. Thank you, Judge. I told you we didn't have a problem with the law and we didn't need any help. And now you know why. And I'm counting on you to follow that. Nobody's asking me any help. We're just asking you to follow the law and be reasonable with the evidence. Okay? And I'm asking you, when you get through with this process, and one of these gentlemen, maybe both, will talk to you. And you remember I said give this much attention as me? Still do that. Okay? But the reality of it is, we have proven, beyond a reasonable doubt, that when you go from this to this, there's a question.
And there's a reality. The reality of it is all this week, including today, the instrument of her death has been seated beyond a reasonable doubt in this courtroom just a few feet from you. And we're asking you, based on the evidence, based on the law, based on your oath, to return a verdict of guilty of capital murder as charged. When you do, close the circle on this, put this to rest, allow it to heal, and let us all move on. Thank you.
Okay, you ready?
Yes, Your Honor. Thank you.
You may proceed.
May I please court?
You may.
State. Ladies and gentlemen of the jury, let me start off also just thanking you for your time as well as your attention that I've watched you put in this week over the course of these last few days. In the grand scheme of things, this actually went fairly quickly. But I've watched you take notes. I've watched you look at the screen. I've watched you read things that are on the screen and different clips and snippets. So I know you've been paying attention, and I thank you for that. I also want to take you back to a week ago when I had the opportunity to speak to you during voir dire. And I told you that that was the most important part of any criminal proceeding. And the reason is because that's the only opportunity that I get a chance to speak to you, you get a chance to speak to me, and we actually can have a conversation. The only reason that you group of citizens are here today is because you took that oath last week that what you had said on Thursday, that answers and responses, whether in the questionnaire and or they were asked of you, that you would tell the truth. And I explained to you, as Mr. Crusoe said, he talks about the importance and the privilege we have of serving on a jury in this country, and I agree with that. But the only way it works is if everybody plays their part. See, the state of Texas has its part over here. They do all the accusing, finger pointing, and all that stuff. And the burden that they have, that we talked about, and we'll get to that more, but just what I told you last week, the burden of proof for each and every element that they've alleged against my client, they have to prove. That burden does not move or shift from this table. This table over here, we're here to protect the rights of Mr. Chemirmir and to make sure that they're doing what they're supposed to do and not doing things they're not supposed to do. Obviously, the judge's role, the bailiff's role, the court reporter's role, but we also spoke about you guys' role last week. And it started with you being honest. And I promise you, this is the only reason that y'all are sitting here is because you told me that you were being honest in your answers. And those answers that you gave last week, either orally, verbally, or in written form, led us all to believe, but specifically me, that you could and would, when it came to this week, if you were placed on the jury, take that second oath and follow the law. That's the only reason you guys are here. In the same way that you took that oath last week, and you took it this, and I held you to it last week, which allowed you to be here this week, I'm going to hold you to that as well. Nothing more, nothing less. To simply follow the law. And all of it's contained here in this charge. And I too also want to point you to a couple of places in here. Before I do, let me think back to last week when I asked you. I said, "Well, what do you think your job as a juror is?" He's like, everybody's like, well, reach a verdict, reach a decision. And I said, wrong. Because you're only able to reach a decision if each and every one of you on the jury believes beyond a reasonable doubt the things that they've alleged. See, you're not here to just go back and to talk and to deliberate and reach a decision. If you can, sure. But that's not your job. Your job is to deliberate. And to vote. And your verdict must be unanimous. If it can be. It's literally that simple. I'm not telling you not to deliberate. I'm not telling you not to communicate back there. But what I am telling you, and you know, Mr. Crusoe said, well, no, you're one big group. But that's not true. Yes, you all, 12 of you comprise a jury. But you are an individual person. You have your individual mind. You have your individual experiences. You make up your own mind regarding what? Page 11. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and the weight to be given to the testimony. Remember the conversation we had last week? Evidence. That term evidence is literally what's admitted and allowed in the courtroom. That's it. The court has no bearing that the evidence was admitted. Who puts the weight on it, the credibility on it, whether it's witnesses, whether it's a video, whether it's photos, is each one of you individually. You take a look at it, you make a determination of how much weight to give, if any. And I submit to you, you know, they brought in a lot of stuff, right? You go over here, you see all these boxes and all this tape, and it's a lot of stuff. You make the determination of what it's worth, what value you give it. And as you do that, not just alone, you think about it has to go to an element. Think about what the evidence that they present and why. You know, every case that I have, I come up with some sort of theme. And I didn't know until probably a couple of minutes ago after speaking to Mr. Crusoe kind of what my theme was going to be for this closing argument for you guys. And then it hit me. As I sat there and looked at all this stuff, and you know, all the boxes, and you know, Mr. Fitzbarton's going to get up, he's going to, you know, push the clips, on the screens on, he's going to show all this stuff. But the more that I listened to the evidence that was presented, as well as what wasn't, I thought to myself, all bark and no bite. It's a lot of barking. They're just barking. They are just barking. Because you, kind of like me, as we sat here, and Mr. Crusoe tried to explain it a little bit, we're here because they made the accusation regarding Ms. Harris. But they bring in Ms. Brooks and Ms. Bartell. And the law says a few things on that. But one is even before you can consider, if you can consider it, because you can only consider it for determining motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accidents. For no other purpose. But the caveat to that is the only way to even consider either one of those, for any of those things, you have to believe that evidence also beyond a reasonable doubt. in a criminal case, the most important thing that the state has to be able to do is what? Prove to you all that the person they're accusing was at the scene. Because without a defendant, we're not here. Someone accused of an offense, we're not here. We're not having a trial. That's the first thing that they have to be able to do. And speaking of that burden, we spoke last week about the different levels of burdens of proof. We talked about, in a car accident or something civil, a civil proceeding, what's that burden of proof? And that's preponderance of evidence. You quantify that on a 100% scale, 51-49. That's preponderance. So what's the next level, Mr. Warren? We talked about kids. So you love your kids? I said, like me, most times, most days. But in order for the state of Texas to take my children from me, or to take your children from you, they have to bring clear and convincing evidence. Think about that. To take your kid, to terminate your parental rights, they have to present clear and convincing evidence. That has to be some pretty strong evidence. Lastly, what's the highest burden of proof across the land? It's what we're dealing with here in this courtroom, beyond a reasonable doubt. And we said, well, what? I asked you guys. Ask some of y'all. Why is that? What do you think? Why do you think it's the highest burden? What are we dealing with? Life and liberty. Life and liberty, high burden. And every single element, every single one has to be proven to each one of you. Each one of you has to believe each and every element that they've alleged beyond all reasonable doubt. We talked about, last week as we had the opportunity to actually speak, ask questions of one another. I said, this is the time to be honest, because every case isn't right for everyone. I said, on a case like this, what if you honestly think he did it, but the state didn't prove it or couldn't prove it? Would you be able to, as you've taken that oath, follow that oath, and acquit the defendant if they don't meet their burden on each and every element? And every one of you that are sitting here listening to me right now told me yes. And that's all that we're asking you to do. And I submit to you, they have not met their burden on each and every element of this offense. And I submit that to you because they cannot. So let's talk about it. So, as we talked about, we call them extraneous offenses. We talk about these other offenses. Even if you want to use them in the manner in which you're allowed to in the charge, you first have to believe that Mr. Chemirmir committed that offense, those offenses also beyond a reasonable doubt. Otherwise, you can't consider it at all. So back in January, we have Ms. Brooks. January 30th, 2018. And here's the, going back to all bark, no bite. They bring in, Agent Sedgwick. Dealt with him before, good guy, good agent. Federal Bureau of Investigation. Boy, that sounds fancy, right? They bring him in here, put his big boards up. See these big boards? And I said, Mr. Fitzmartin, he's going to put them up for you. You better see him. I won't be able to see you because, the boards are all big. I won't be able to see you. And he's going to have his, he's going to talk about these hot dogs and is it consistent with, think about those questions that were asked by Mr. Ananastis. Is it consistent with and all these other things? But January 30th, Ms. Mary Brooks, as she's found by her grandson, they have Officer Harris comes in. They sweep the home. He looks at her. He said, I immediately could tell that she was deceased. Officer Harris says he makes the proper phone calls. They speak to who he needs to speak to at the ME's office. Calls her doctor. Natural causes. Natural causes. Older lady, natural causes. Fast forward. Dr. Bernard comes in and does a different report based on what? Honestly think about, and take back States Exhibit 293. These 7 findings, because that's the only thing that's different than what occurred that day. Nothing new was added, except for basically, it reads now like a police report. But what I asked you, I said, Dr. Bernard, so outside of this information that you received from the police department, did anything change? Because you had Officer Harris, an experienced officer, as well as a couple other officers that had some crime scene and some other experience, several years, several decades of police experience. And you saw on the body cams, he looked at her neck, he rolled over, looked at her back. Even Dr. Bernard called them superficial injuries. Nothing out of the ordinary. Nothing changed. Nothing scientifically or medically changed. Except for the information provided to Dr. Bernard by the police department. That's it. So without that, and even then, it's just that things were missing. Mr. Crusoe talks about this safe. What safe? They didn't find a safe anywhere. There's no evidence of Mr. Chemirmir having that safe. Don't consider everything that's admitted. You don't have to take its face. As a matter of fact, you're required not to take it on its face. You're required to listen to it, evaluate it, and then you make a determination and/or a decision. Trying to raise, to lower the weight of that evidence. But that's the only thing that's different is things were taken by someone. What couldn't or didn't they prove? That Mr. Chemirmir was there. So they bring you, evidence from the Walmart. Sergeant Pagel from Richardson PD said, "Well, yeah, Altima is an extremely common car, and there's nothing unique about the photos of the car they saw. Not a dent here or a spoiler there, or a different door color. You couldn't make a determination of who was driving the car, male, female, race, nothing. Evaluate that evidence. Think about it. The medical abstract of death certificate for Miss Mary Brooks. Cardiovascular event, sudden death, immediate, related to hypertension, chronic. Think about it. That's not beyond a reasonable doubt. All bark, no bite. So then we have Miss Bartell, March 19th, 2018. By way of deposition, think about what she said. And what she didn't say. She couldn't identify the race of the person. She actually said, I was having a dream. I thought I was having a dream. She couldn't identify race. Well, she also said, she did one fact that she was very particular about is that her attacker spoke well. Well, what do we know about Mr. Chemirmir. In defense exhibit number 3, take it back, listen to it. He has a very heavy accent. Very heavy. It's extremely heavy and very noticeable. And Mr. Fitzmark said in his question, in his cross-examination, where he said, "What did the person say? Well, get back, don't fight me." Would that make a difference in a person's accent? I submit to you it would not. It's not an accent that's turned on and off. You have it, listen to it. This goes towards identity. They have to place him there. Beyond a reasonable doubt. They do. They haven't because they can't. So now we're here with Ms. Harris. Riddle me this. On the day we're actually here for, the most important day of March 20th, Agent Sedgwick didn't have all his fancy hot dogs and all these things on the map, does he? It's a little peculiar. You weigh that evidence or lack thereof. What does that mean? So, you know, because their whole theory of their case is Walmart. Walmart. And they even said, you know, Mr. Cruzos even said, you know, he was acting like he was on the phone. What Agent Sedgwick said is there wasn't a phone call made during that time. You don't know what he was doing on that phone. And we don't have to prove that to you. They do. But so you say, well, why'd they put that up? To inflame you. Make you think it looks bad. So what was he doing there? It's March 20th, 2018. What do you see? As Ms. Harris arrives at Walmart, and approximately almost 40 minutes later, Mr. Chemirmir does as well. A few minutes after Mr. Chemirmir arrives, he's about to check out. Ms. Harris is already in her line. Mr. Chemirmir goes to his line. And I submit to you, then he does what I submit to you that every one of us has done before, whether it's at Walmart, Sound Thumb, wherever it is. You walk up to a line, as you're walking up, you're looking for a line, you find a line. If it's like me, I always pick the wrong line no matter which one it is. It's going to take a long time. So he sat there and then he walked over, took a little look-see, and walked back to his line. I asked Detective Sayers, I said, Detective Sayers, you know, you were responsible for watching the video from Walmart that day, right? He said, yes, sir. I said, at any point, did you actually see any interaction between Ms. Harris and Mr. Chemirmir? No, sir. And I promise you this. If they had it, you would have it. The reason they don't have it is because it didn't happen. No interaction. And think about the things that they put in front of you that they want you to use as evidence against Mr. Chemirmir. They bring in this clip of Mr. Chemirmir as he's leaving. Stops next aisle after he already checked out, got himself together. And then he gets a drink of water. I guess you're not allowed to drink water. He gets a drink of water, and then he leaves. But see, they want anything that Mr. Chemirmir does, it's nefarious. Woo! Well, what's he doing there? He's got to be watching her. No. He stopped, got himself together, got some water, and he left. Before her. Before Mrs. Harris. What didn't they tell you, though? Nothing's nefarious when Miss Harris did the exact same thing. That same camera, she pushes up, you see her cart stop. She got herself and her stuff together. and proceeded to exit the store. Not only are you allowed to, you're required to take into account all of that kind of information. Ask yourself, what does it mean? All bark, no bite. So then they get to the parking lot, which Mr. Chemirmir gets there first, gets to his vehicle first, gets in his vehicle first, pulls out of this parking spot first, drives off and away first. They make a big deal about he pauses at her car. Take the video and look at it. There's a worker from Walmart with a vest on pushing a cart in front of him, which is why he stops. There's no evidence there's still any interaction between Mrs. Harris and Mr. Chemirmir. Then he leaves and exits almost 2.5, almost 3 minutes later. Earlier than her. So she leaves almost 3 minutes later. They happen to leave the exact same way in exiting the Walmart. And he turns right, and she appears to turn right 3 minutes later. So they ask Detective Sayers, "Hey, Detective Sayers, what's that way?" "Oh, well, that's towards her home." "Okay, Detective. What else is down there?" "A lot of things. Other stores, other places and things." Detective Sayers, did you get an opportunity to go back along this major thoroughfare here? Whether it's a post office, a gas station, did you maybe go in there and check, see about these cameras? "Yeah, well, it was an excuse." "Well, it kind of depends on when you get that information, of if you're able to garner anything of value." So the short answer, Detective, is no. You had nothing showing Mr. Chemirmir stopping and following or jumping behind or anything like that, or again, additionally, any interaction. No, sir. You're correct. All bark, no bite. So then later, based on the information that they received, and they set up on Mr. Chemirmir's home. Excuse me. They set up on Mr. Chemirmir's home. The officers, all the detectives from Plano, they set up on his home up there at Pear Ridge. He pulls in, goes to the dumpster. They arrest him after he drives to his parking spot. They arrest him. After they arrest him, and they search his car, and they also go to the dumpster. And in the dumpster, they find this jewelry box that you have before you. And as you notice here on these photos, states 124, it's intact. Both doors to the front of the jewelry box are intact. What you have before you here in the courtroom is not. States 125, a larger photo. You have here Detective Garcia on 127. You heard me ask him who's holding it. And the irony of this photo is he has his gloves on. And the gloves are for what? To protect the integrity of the evidence. We heard that term a few times. So we're concerned about the integrity of the evidence, so that what? So there could be testing done, there could be fingerprinting done. DNA possibly. But then what do we do? Or I shouldn't say what we do. What do they do? And when I say they, I mean the state of Texas, because Detective Garcia, as a member of the Plano Police Department, state of Texas. So what do? Finds a box from the garbage. I'm not saying it's TV, where every case the budget would be about $2 million if you would watch NCIC or something. But I promise you, the city of Plano can do much better than finding a trash box out of the trash to put evidence in. Evidence that they want to use against my client. But that's what they do. So not only do they grab a trash box, then they just haphazardly just throw the box in there, the jewelry box, breaking the door. And you say, so, Mr. Ward, what does that mean, though? Like, what it means is they want to use this evidence or these things as evidence to convict my client, Mr. Chemirmir, but they want to protect its integrity. Whether it would hurt or help him, maybe. And if they're so haphazard with this, what else are they haphazard with? You'll have to take that into consideration in assessing that burden of proof. So based on some of the things they find out there when they arrest my client, they make it to Ms. Harris's home. They do a welfare check. They find her deceased, find her on the floor. Which is also, interesting. As I spoke to one of the detectives that made it out there, I can't remember if it was Claggett or not, but I asked him, I said, well, when you went into the home and you saw on the floor, was it apparent that she appeared to be deceased? He said it did, and she did. I said, did you touch her or do anything? No, we did not. And look how she was found in states 187 and 188. On her side, on the floor, with things on her head. So the detective, did y'all knock that on her head? No. Could it be that she had fallen? And as she fell, those things fell on top of her? Possibly. Then they said, think back on 189. On 189, the bed, how it was made, as well as on 187, you can see that the bed is made. All the pillows and such are covered. Speaking of pillows, I know you've heard the word pillow more than probably you ever thought you would in a matter of a few days. Judge Trudeau pulls up this pillow, and I want you to think about this. They said it. They're witnesses, and they repeated it. 3 distinct lines, right? And they want to say that's a smear. What did Dr. Danielson tell you regarding the petechia and all these other things causing constraint? He said, think about it. He said, in a situation like that, one will be fighting for every breath and doing what they could. So what is a natural response if something is pushed over your face? As their theory goes. Would it be 3 distinct lip lines? Or at a minimum, regardless of age, regardless of strength, wouldn't one turn their head away from where the pressure is, or try to? Well, you don't see that there, do you? That's not a smear. As I said, that's 3 distinct lip lines. A smear would be this. That's the natural response. Dr. Barnard, as well as Dr. Danielson, both agreed with me that petechia can come from several different things. How long does it last? Kind of the jury's out on that. But it can come from different areas of strain. No evidence of hemorrhaging in the section of the anterior strap muscles, the back of the neck. There won't be straining for air. She had some arterial nephrosclerosis, which is what? Clogging of the arteries of the heart. And this goes back to my all bark, no bite. Dr. Danielson said, I said, well, doctor, isn't it true, because the heart is a muscle and it's straining because of the blockage in the arteries to pump blood to and from the rest of the body. With that plaque that's built in there, that strain, is it possible to cause that petechia on the heart? Well, no. But then I showed him some prior testimony of his where he had said yes, and he had to concede that point. Why fight me, doc? Why fight me? Doesn't fit the state's theory. All bark, no bite. The court does not determine what weight should be given such evidence, nor does it pass on the credibility of the witness. Because that's up to you all. Each and every one of you. And we also talked about the presumption of innocence. What do we say about the presumption of innocence? The common phrase that people say that I got you to think about is innocent until proven guilty. I said, no, that's wrong, though. Because what's wrong with that statement? It said until means we're just waiting for that person to be found guilty. Is properly it should be innocent unless. Unless. That's that presumption. And in the charge, it says that presumption is sufficient and enough to acquit Mr. Chemirmir. These they have Ms. Bartell and Ms. Brooks up here. And here's the thing, ladies and gentlemen. The law says, and it's clear, you can absolutely believe one or both of those two extraneous. The issue with Ms. Brooks, the issue with Ms. Bartell, and still not believe that they've met their burden. Because what they've proven, at most, at best, is that at some point he was in possession of stolen property. But you also have to make a determination of whether you believe that beyond a reasonable doubt. You say, well, Mr. Warren, that's silly. Is it, though? It's not. It's your burden. That's what you guys are here for. You have to take everything that they've alleged against Mr. Chemirmir and make that determination. And I submit to you, they've not been able to place him anywhere They've not been able to place him anywhere. Now it's 2022. Then it was 2018. You're telling me that on these 3 different instances, they brought in the big old FBI, not a single Ring doorbell, not a single nosy neighbor at a apartment complex, at a retirement community, in a close-knit old neighborhood. Not a single person or shred, sliver, or anything of evidence that places Mr. Chemirmir or anyone that may or may not meet his physical description on the days in question. Especially and specifically on March 18th, 2018. March 20th, 2018, with Ms. Harris. Start.
You have 5 left.
Thank you, Your Honor. You have to start there. Ladies and gentlemen, they can't even put him there beyond a reasonable doubt. Circumstantial evidence, first direct, doesn't matter. You put that amount of weight on there. You make that determination of what weight you want to give. Because what does circumstantial mean? It's just that. Is there another reason? Could be. But more importantly, do you believe why they're putting it forth? Beyond a reasonable doubt. Not just a probability. This is the great state of Texas. They don't need any help. And the law requires you not to give any help. If there's a benefit of the doubt, what's the key term in that phrase? Doubt. And where does that go? This baseball tie goes to the runner. Who's the runner? It's Mr. Chemirmir. No identity. Can't place him there. Ms. Bartell. March 19th, the day before he's arrested. In that Hyundai Sonata. Speaks well. Approachable gloves. I don't remember what he had on. Don't know his race. Next day, they searched the car. They searched that Sonata. No gloves. But the things he bought from Walmart are still in there. Beyond a reasonable doubt. Every single one. With Ms. Brooks, I submit to you, you have to make a determination of whether or not you believe that she was smothered. They were even conflicted. Only difference is they said some things were taken. That's it. Nothing medically, nothing scientifically changed, nothing different there. Identification. Same with Ms. Harris. They had the next door neighbor had a Ring doorbell, motion activated. Detective Shelton said, "Yeah, I went over there and we went through it for hours." Mr. Hayes asked him, "Did you find anything?" No. State wants to make some excuses. No excuses. Did you find anything? Did you see a car? Did you see a gray Sonata? Did you see a black man there? Did you see anyone approaching her home? No. An indictment that you can't believe or prove that the defendant is there is deficient. And the only remedy there is an acquittal. Might hurt, might sting. You say, well, Mr. Warren, some of this stuff is it just looks bad. The optics are terrible. Doesn't matter. You guys are sitting here because you said that you would hold them to their burden. And that's all that we are asking you to do. That's all that we're asking you to do. Beyond a reasonable doubt, the highest burden in the land, they didn't get there. Because they can't get there. It's impossible. Because they can't place him there. If they can't place him there, then they can't get there. And as I told you during voir dire, you're one jury, but you all make up little individual juries. You know you better than anyone else. You know what's reasonable to you. You have to make that decision. And once you make up that decision yourself, then you can come together. What do we talk about also? Juror respect. You respect one another. It's not your job to try to change anyone else's mind. You have your opinion, they have theirs. You discuss it. If there's some movement, so be it. If not, it is what it is. And the law allows you and requires you to hold fast to that. You don't have to violate your conscience. You're not in a race to get out of here. It's not, oh, well, we're here, we're done, let's go. Because what are we talking about here? Someone's liberty. So I submit to you and I request that each one of you just simply do what you told me you would do last week. Follow the oath that you took on Monday. Hello?
Sorry, Counselor. That was your time.
Okay. Can I sum up this last thing then?
You may.
Thank you. Is to simply follow the law of the oath that you took on Monday. And that's to hold the state to its burden of beyond all reasonable doubt. And I submit to you that if you do that, that's all that we can ask. Hold true and fast. Do not violate your conscience. Respect one another. And I submit to you the state cannot reach their burden. And we're going to ask that you find Mr. Chemirmir not guilty. Thank you. Thank you.
Have a moment to look like they can cut off. You might want to stretch or anything while we're waiting on this. May I please the court,
May?
counsel? All bark and no bite. All bark and no bite. Do you remember how we started this trial after you took your oath? It started with these words. True bill of indictment. You remember? That's how we started this. Those were the first words I read to you. True bill of indictment. That was me barking. True bill of indictment. That was me barking. All this stuff, that's me biting. Okay? All this stuff is actually not stuff. It's evidence. It's evidence of the guilt of Billy Chemirmir in the death of Lou T. Harris. That's what this is. Plain and simple. Ladies and gentlemen, when we started this journey together back last Thursday, and you all came in there as individuals, not knowing what case you were here on, not knowing what this is about. Are you here on a DWI? Are you here on an aggravated robbery? Are you here on a sexual assault? You don't know. Then you learn that you're here on a capital murder. This is the pinnacle. This is the Mount Everest of cases down here. And do you think that we are going to let anything go unturned, any stone not investigated in a case like this? Absolutely not. And when the law allows us to bring in the type of evidence, the quality of evidence, the quantity of evidence that we brought to you, do you think we're going to do that? Absolutely. Because he's right. We can't just stop at barking. We got to bite. And that's what this is. We brought you every bit of evidence the law would allow us to bring in this case to prove to you that that man right there is capable of taking the most innocent of objects, the things we put our children's heads down on at night so that they can have the dreams, as Mr. Crusoe told you, and he turned them into instruments of nightmares. Not only for the women that he accosted and attacked, but for their families to learn. Think of Mrs. Brooks's family, that they had to learn that their mother, that they put to rest 7 weeks before, actually found her end looking at that man right there. What must that be like? You know, we see this pillow, we've been pushing it around and picking it up, and I might pick it up here in a minute. But keep in the mind that all of these women, and I know Mary Bartell lived, but he didn't intend that. That the objects of their lives are turned against them at the hands of this man. I am going to go through the evidence. You know, we started with this, and if you wanted to, remember we talked about this in voir dire? How we could pick apart, and if you look at the left side, what is that? We don't know. If you take apart this one little bit here, and maybe this one day over here, and well, we can't see him in the Altima on this day. If you look at those in individual pieces, we struggle in our case. Absolutely, we struggle in our case if you look at it individually. But that's not what you're supposed to do. You're supposed to take all the facts and all the evidence and view it together. And when you do, even if there are holes, you still know what that image is. You cannot separate out these three ladies because they're all connected. They're all elderly. They're all attacked in their homes. They're all missing jewelry shortly thereafter. One leads to the other, leads to the other. But where does our story start? It starts with Mary Bartell. It starts with a 911 call. My neighbor can't wake up. We can't get her up. That's where our story starts. And it is because of Mary Bartell, it is because of that pacemaker that's put inside of her to keep her alive that we were able to have this story. But for Mary Bartell, would we be here today? Or where would we be today? Or where would other people in our community and other families in our community be today?
Judge, I'm going to that argument there. It's improper.
You'll recall, or I will tell you that the arguments from counsel is not evident. You'll recall all the evidence and testimony that you heard in this case. You may proceed.
What we know is that while she is at the hospital, while she is being tended to, while her sons are there with her, Billy Chemirmir is over posting her ring. And it's not just any old ring. It's the ring that has been on her right hand for 50 years, given to her by her husband. She's knocking at the door at 8:30. 911 call around 9:40. What time do we have here? About 10:30. He's put it on his own ring finger and taken a picture of it with his own phone. He offers that up for $1,200. And luckily, because of the diligence of the Plano Police Department in tracking this down, bloodhounds up there trying to figure out what happened to Mary Bartell, we find out that Abdel Saleh bought that ring. They take that picture that's right there, bring it back to Mary Bartell. Is this the ring? Absolutely. They show that to Abdel Saleh. Is that the ring? 100%. You heard him say it 7 times. Tracking him down. Biting? Absolutely we're biting. Plano Police Department gets a suspicious person's call. Well, it goes to the office. Do you remember Richard Plink came in here? I went and picked up my mom, a nosy neighbor. Remember we talked about nosy neighbors, right? Yeah, nosy neighbor. 4 days before Mary Bartell, right outside her apartment, there's a man sitting there, standing there, loitering, hanging out. Goes, takes his mom to doctors, takes her to lunch, comes back. Man's still there. Doesn't sit right with Richard Plink. Just doesn't sit right. Something's not right about Billy Chemirmir that day. He goes up, asks him, hey, do you need something? What's going on? Have a little conversation. Man says, no. Gets in the car, scurries away. Remember Richard Plink says, I went up to make sure I could get the make and model. And then I pulled out, once I got the license plate to write it down, here he comes taking off. He knows someone's onto him there. But 4 days later, he feels confident enough to come back to find Mary Bartell. Plano Police Department gets this information. They go to work on this license plate that same day of Mary Bartell. They find out Tom Onding owns that car. Something's not adding up, though, because the car doesn't hit at Tom Onding's apartment. It's hitting over at this 4,500 Pier Ridge. They look for any kind of reports. What report do they find? An accident report from March 17th. They ask, why is there any gloves in the car of the Sonata? He doesn't even have the Sonata on that day. He gets it later on the 19th. He doesn't even have it yet. They find out that there's a car. They get a name, Billy Chemirmir. Name doesn't sound right, doesn't spell right. They figure out the proper spelling. They get a phone number. With that phone number, remember, they start the pings. They go up, they know they have an address, they know they have a name, they know they have a phone number the next day. They set up in this apartment, 7, 8 of them, looking for Billy Chemirmir. Open spot number 67. Finally, later in the day, as they start pinging, remember the pings were real big at first and covered a larger, I don't know, we went through meters, feet, yards, whatever. I don't know. There was a bunch of math here with this distances. But they were too large to zero in. Then they started getting smaller, and then finally that last ping, right when Billy Chemirmir shows up. He's taken down on a felony arrest. You remember that? Guns drawn. What's he have in his hands? Jewelry. He's shocked. He's sitting there. That look right there, game's up. We got you. But now this is the next day, remember. So there's still the Mary Bartell the day before, and now we're at the 20th, later that day. In his hands, they get his phone. Thank goodness we have his phone. Tells us a lot. Random jewelry, $2 bills, envelopes. Remember Detective Knight? Where was he? Remember he was over by the dumpster? What did he tell you he had heard? He had heard, well, when he saw him come and go, heard some banging, saw a jewelry box in there. Remember, I brought this picture in. This is how the jewelry box should look, right? And look at how it's all banged up. Now, granted, the door came off. Big whoop. Okay? But here's what it looked like when they found it inside there. All banged up. Right? Remember he said, yeah, I could hear some banging not only at the dumpster, but at the over at the car. And you can look in this jewelry box, there's bang marks on there. That latch is supposed to come down over that. That's Billy Chemirmir breaking into this jewelry box to get the things because it was all locked up. They find individualized items inside this jewelry box. What do those things go to? A known address. They go to work on that. That Plano Police Department, they give this information to Detective Harp. Can you look to see if there's anyone named Lou T. Bang? Why? Why are they looking for this? Because they know about Mary Bartell. They know that there's an individual out there that's capable of taking a pillow and put it over an elderly woman's face and taking her stuff. Well, now they catch him with someone with some new items and a new name. Well, let's just go see where this leads us. Where does it lead us? 6609 Warm Breeze. And when they go in there, that door, that house is tighter, locked up. What do they have to do? Break in to get inside there. And what do they find? Lou T. Harris. The fear of a police officer and his investigations that has it happened again in my community, the community we're here to keep safe? Absolutely. The realization dawns on them. They not only have the individual who attacked Mary Bartell the day before, but now they have a new victim, Lou T. Harris. Well, are we going to stop at that just because we have someone who has attacked the day before and in possession of her items? No, we continue the investigation. We look inside there. We know the story of Mary Bartell. A pillow was placed over her face by an individual who says, "Get in, lay down, don't fight me." Do you think she was listening for an accent that day when those green gloves came at her? Absolutely not. What do you think? Do you think Miss Harris was focusing in on whatever accent was told her when that individual came into her domicile, her house? We know that this pillow right here was used as the instrument of her death. I don't care how those marks got there, this way, or that way. They're there. What woman is going to put these, lay down, flat down on her pillow and rub her lipstick on here and then just flip it over and leave it there? Is it really that hard to wash lipstick out of pillowcase. Absolutely not. These are the little bitty things of the puzzle piece that they want you to focus on rather than looking at the whole shark. Ladies and gentlemen, this is the instrument of the death that was used, and the doctors told you that. 2 doctors told you that. The keys. He gets this jewelry box, which we have no other explanation for this jewelry box other than the fact that he took it out of that home. He took the items of his interest out of that jewelry box. Why? Why on earth? Either these came out of the jewelry box and he kept them, or he took them from the home. Somehow he has the keys that opens the doors to this house in his car. Ladies and gentlemen, we call biting around here. Walmart's receipt. They don't stop there. Not only do they have the keys to her house, not only do they have individualized items that belong to her, they go back to Walmart. What do we find at Walmart? Boom, Lou T. Harris. What do we find next to her? Boom, Billy Chemirmir. Checking out. Is he loitering after he gets done? I agree. She stops and puts things in her purse, her credit card, whatever it is, put away, as most people will. It is different when he stands over there in a position where she is right here, putting his money, putting it together, being so concerned about everything. If you go back and look, he leaves the receipt. How is he getting his stuff in so much order that he leaves his receipt right there? Then he goes over to the water fountain, and he's drinking his water as she is walking up. And it just so happens his thirst is quenched right when she walks up. He is on her. He has made the determination at that point in time, this is his next victim. Plain and simple. What do we find out then? We go back to our picture of Lou T. Harris, and I showed you this. You all remembered it. But these items here, State's Exhibit number 147, the same green ring that's on her hand, precious to her. The same bracelet that's on her wrist. He's holding these in his hand when he's arrested. A necklace with her nickname, Kim, in his hand. The $2 bills that she finds to be quirky, stacks of them, in his hand. Ladies and gentlemen, if I had any more, I don't know. Great. I wish I had a snapshot of him walking out of the house. Do you need it? Is there more you really need than to find that these 2 individuals, 2 hours from Walmart to throwing the stuff out? Do you really need more? If you do, we brought you some more. Okay? We brought you Mary Brooks. Mary Bartell, looking for her assailant, leads us to Lou T. Harris. After we find out we have an individual who's capable of putting a pillow over an elderly woman's face in 2 different incidents, well, let's look back to see what happened to Mary Brooks. Because you know what? Something wasn't right. Did you not hear that in Officer Harris's voice? Something wasn't right. He saw that scene, how he found it. There was groceries left out. Her blood pressure deal is there, showing you the 30th. And you know what? If that's what she died from, I should be dead 4 times over by now. Okay? He knows that there is something not right. He does what he's supposed to do. He calls in his information to the ME's office, and they say, you can go ahead and release her. But ladies and gentlemen, this is her at 10:51 that day on January 30th. They bring you a document that says she died January 31st, right? And show that that's what the official ruling was back then. It was January 31st. Well, look how she's dressed in that on the January 30th and how she is on when she's found on January 31st. Are we to believe that she went all day the next day and all night that night and wore the same scarf and the same blue jacket? Absolutely not. You know what happened. She walked in there. She had her bags of groceries, the frozen items, made it to her kitchen, put down her keys, was heading back just like David Cudahy said, went to go lock her door like she routinely does, and boom, Billy Chemirmir's right there, meeting her, putting her down on the ground, suffocating her, smothering her. How do we know it was him? Because we got his OfferUp account. How do we know he did this? Because when you click on the URL, this unique ring, this ring that was passed down from her mother to her and should have gone to Ann Brooks in the inheritance, no, went into his pocket to be sold. Tried to sell it on OfferUp for $5,000. What happens to it? It winds up probably here at Diamond and Gold Exchange on one of these two on the 31st. He had already made a sale for about $2,000 the day before on the 30th, and he makes another sale on the 31st. About $5,000 or a little bit more from those two sales on those 2 days. And Ann Brooks told you about the amount of things that were missing from that house. That was a windfall for Billy Chemirmir. Remember, he only sold Mary Bartell's ring for about $380. $380 is the life of Mary Bartell. $5,000, I guess, is the life of Ann Brooks.
You have 5 legal counsel.
Thank you, Judge. Ladies and gentlemen, you cannot tell these 3 women's story without knowing each other. And you can't tell Lou T. Harris' story without the other 2. Mary Bartell tells us what happened to Lou T. Harris in the smothering. Ann Brooks tells us what happened to Lou T. Harris in the coming out of the same Walmart. I'm not even getting into the phones. You heard it. Mr. Anagnostis presented that to you in a so precise manner. You followed that detail every step of the way. I watched you. I got a front row on there. Every place we think Billy Chemirmir should be, his phone is there. Every single time. Investigator or Agent Sedgwick doesn't know these things. But remember what he told you. Sometimes the phone can confirm something that you don't know. Sometimes the video is going to confirm the phones. That's why this is here. You can take this back and you can look in more detail how we have come back and forth to confirm the phone with any other evidence we have. Ladies and gentlemen, these 3 women didn't know each other. But they are all connected. They're all connected by Billy Chemirmir. Because this is the individual that took Lou T. Harris's life. This is the individual that took Mary Brooks's life. This is the individual that tried to take Mary Bartell's life. You can't know this story without knowing each of them. But the sad thing is that the last face that these poor women saw, or the last face that was intended to be seen by Mary Bartell, is the face of that man right there. It's not of their daughter or their son or someone that's going to comfort them in that final moment of journey. Absolutely not. It is terror. It is fear. It is greed. That is what's looking at them. Get on the bed. Don't fight me. He speaks elderese. He knows what he's doing. He knows how to blend. You saw him at Walmart. You saw him loitering. You saw him on his phone. No one there took any account of him. Lou Harris looked right at him and took no account of him. Mary Brooks was parked right next to him and took no account of him. He was outside Mary Bartell's apartment and took no account of him. That's how good he is. He was able to leave Mary Brooks's house in such a way that trained investigators had no idea he had been there. You have a duty to do in the criminal justice system. You are charged with returning a verdict. They talk about your individual minds, and I agree. We all have our own individual mind. But there is not a space here for every individual person on this jury. There is a space here for one, the foreperson, who will speak for you as a unit to determine the fate of Billy Chemirmir, to determine justice in this county, to put an end to this violence, to bring some sort of closure to those who have been affected. This is an easy decision, mainly because we bit so much off. You are instructed to go back, to deliberate, and to render a just verdict. And when that verdict is a verdict of guilty, it will be loud, it will be proud, it will be justice, and it'll be nothing and no amount of surprise to this man right here. And it'll be what he deserves. Please bring back a speedy verdict so that we can put an end to this. Thank you.
Thank you, counsel. All right, ladies and gentlemen, you have heard all the closing arguments that you will hear in this case. At this time, I will allow you to retire to the jury deliberation room. And once you get back there, you will select your foreman. After you select the foreman, you will then be able to begin your deliberations together. At this time, I need to step. That's fine. We can do that. All right. That's it. So at this time, ladies and gentlemen, if you would rise, you can turn to the jury deliberation room. I'm going to need to wait back here with me. I need Mr. Cobb and I need Mrs. Foster Dykeman. Angie? Okay. If y'all two will wait back for me. Thank you. Everybody else can return. And Deputy White, that's it. Okay. All right. Here's the y'all can be seated. Yeah, come on. Come on, right there, good. Because y'all can hear me, right?
I can hear you.
So we know it only takes 12 people. It takes 12. So at this time, Ms. Dykeman, you'll be allowed to, we'll have a place for you to sit. All right? And Mr. Croft, you're released.
Completely.
You're released. So we will now allow our 12 to deliberate, and we're going to be in recess. All right. Thank y'all. you as previously, where we will direct the jurors to the bottom of the jury charge, page 11, the last paragraph, and that's how the note will be. So the jurors will be directed to the jury charge. We will then tell them that go to page 11, last paragraph on page 1.
And that's over our objection.
That's over the defense's position.
We're asking just to send back.
Yeah, Judge, really, the top of page 7 also, I mean, if you do not so believe or if you have a reason without thereof, or you're unable to agree, you will then consider whether the defendant is guilty of much. Yeah, so they should, if they have both verdicts, yeah, if they have both verdicts, they wouldn't really be worried about that if they read that paragraph at the top of 7.
Yeah, we had all discussed that because if you look at all the application paragraphs, it beats them somewhere, but the bottom line is, if we look at 11, their direct question is, you know, who signed the place? And this is telling you, you're going to sign the place, whatever place that is. All right, we are on the record. So there has been some discussion regarding a note that was sent out by the jury. The jury sent out one note, and in response to that note, the court is sending back a response that redirects the jury to the actual jury charge. It will read that they have all the evidence in law, or all the evidence and testimony that they're receiving in this case. And we'll say in regards to the jury charge, we will direct them to page 11, the last paragraph on page 11. And I believe that the defense has objection.
We object. We think that it should, the response should just be, you have all along evidence that you need in this case. We think that by the judge or anybody pointing into a specific area that may affect their deliberations, or maybe take it as common or maybe hasn't. My understanding, you overruled that objection.
I do.
And the second request, would you read the letter so Mr.
Yes. Note 1 from the jury states, on the verdict form, do we sign a both verdict levels? We have a verdict, and it is signed by the chairman of the jury. And the court's proposal is that we direct them to page 11, the last paragraph. That last paragraph states, after argument of counsel, you will retire and select one of your members as your presiding juror. It is the duty of your presiding juror to preside at your deliberations and to vote with you in arriving at a verdict. Your verdict must be unanimous, and after you have arrived at your verdict, you may use one of the attached forms by having your presiding juror sign a particular form that conforms to your verdict. So that is what will be sent back in the court's response. And I have noted the defense's objection, and that response will be sent back to the jury over the defense's discretion, I have overruled that objection. Okay, off the record. You may all be seated. All right, ladies and gentlemen of the jury, it's my understanding that you've reached a verdict. And is the foreman, Stephen Johnson. All right, Mr. Johnson, has the jury reached a verdict?
We have now.
And what is the verdict of the jury?
Guilty of capital murder.
Okay, thank you. You may be seated. So at this time, does anyone wish to poll the jury in cause number F1875401? So there's been a request that the jury be polled. So we will go down the line, and each person will need to state out loud if this was the verdict that you reached. We will start with you, Mr. Johnson. Okay, so this was your verdict. All right, next. Yes, guilty.
Yes.
Yes. Yes.
Yes.
Yes. Guilty.
Yes. Yes. Oh. Wow. I thought we got past it. So, Ms. Dykeman, thank you, but yes, the verdict is not. So, having polled the jury and the 12 jurors that were seated stated unequivocally that yes, that was their verdict. So, at this time, is there any reason in law why your client should not be sentenced?
No legal reason.
If you would stand for me. Having received your plea of not guilty, I find that you were competent to enter that plea of not guilty. I find that you entered that plea freely and voluntarily. At this time, having a jury of 12 that have found you guilty of the offense of capital murder, it will be the sentence and judgment of this court that you will be taken by the Sheriff's Department and safely held until you can be released to those persons at the Texas Department of Criminal Justice, where you will serve a sentence of life without the possibility of parole, as outlawed or outlined in the people. Thank you. You may proceed. All right, ladies and gentlemen, having completed the jury trial of this case, at this time, the case in cause number F1875401 has now ended. I want to thank you for your service. I will allow the jury to retire to the jury room. Once you retire to the jury room, sometimes lawyers like to actually come and talk to you and get your impressions. You're welcome to stay and talk to them. Or, now that you will be out of the jurisdiction or not under the order of the court anymore, you're free to stay or you can go. But at this time, I'm going to ask that you return to the jury deliberation. Thank you.
All right.
Okay, you can all be seated. All right, so let me say I want to thank everyone who has been here. Thank you for all of your decorum on both sides, professionalism that everyone showed. We know that this was hard for everyone, but justice had to occur regardless however that came out. I just want to thank everyone who actually came into the courtroom. This has been the first time that we've had the open courtroom. And I just want to tell everybody appreciate that, and we are all free to go. Thank you so much.
Except for Billy.
Okay.
You'll let us know, Judge.
Yeah, I'll come out and go get it.
Yeah. I got it.
Camera's off, please. Off. Thank you. If y'all want to step outside, Lenny's going to talk to Jerry, and then we'll go upstairs to Tanya and talk to you guys. Okay? All right. Okay. All right.
Oh, hey, I got it. Okay.
Yeah? Yeah? Oh, I'm sorry. Wow. Expand.